Well, good morning, everyone, and welcome to our September Richardson Harman Ober webinar on homeowner association or common interest development discipline. Appreciate all of you joining us. We have a number of people I can see from the screen signing in even as I speak. Let me remind you of a couple of bits of housekeeping, if I may. First, if you have questions, I will be responding to questions and answers during the final 15 minutes of our 60 minutes together. I will not be responding to questions during the 45 minutes. I have a lot of ground to cover and want to make sure that I get through all of it with you for your maximum benefit. There will be, but use the chat box, please, to ask questions. There will be a 15 minutes allocated 45 minutes from now to handle questions. And we also have materials that are available for download. They were also emailed to you, and hopefully you received those okay. All right. When we talk about discipline by common interest development or by homeowner associations, it's not a particularly pleasant topic. It's certainly not something that most homeowner association volunteers and even managers look forward to doing, because by definition we're dealing with people who are not being or apparently not being good neighbors for the rest of the community. And it puts the homeowner board in the role of a jury, in that you're being asked to decide whether a member violated or did not violate the association governing documents, but you also have to be the judge. You're asked to decide, as judges do, what will be the penalty for the violation of the association law or the association governing documents, which of course are law. And we also have you in the role of executioner or marshal, because the board is going to decide, not only decide whether somebody violated the rule or the CC&Rs, they're not only going to decide what penalty, but they're also going to be in the role of enforcing and having to carry out the penalty. And by the way, live with the consequences of that discipline for the homeowner. So that's the conundrum, is you're wearing three very important hats that in our regular justice system are separated into three completely different agencies. Let me start, though, with a concept, and I really want to emphasize this, so I'm going to go black screen for a second deliberately. Don't be panicked, but I want your full attention on this concept. We talk about discipline. One of the things that we have to recognize, whether we are lawyers, whether we are managers, or whether we are homeowner directors, okay, I know you're listening, so I'll put this back on. You have to recognize one thing, that so many people that buy into common interest developments or homeowner associations don't understand that although they acquire a deed to the property, that they still have to submit to the jurisdiction, they still have to submit to the will of the entire community. And I can't tell you how often it happens that we struggle with our members that just don't really understand that they are required to be good members, and that means that good neighbors and good members, and that means they can't do whatever they wish. So know right away that when you're dealing with discipline issues, you're not always dealing with somebody who's deliberately trying to be a jerk. You may be dealing with people who just don't understand what their responsibilities are to be good neighbors to the rest of the community. All right, and that may put you in a different frame of mind as you're looking at dealing with violators. Give them the benefit of the doubt to start with. They may not really understand, first of all, that the association can tell them what they can do or not do with their balcony, what they can or cannot do with their patio yard or what have you. All right, so now once we've dealt with that first consideration, and we're dealing with possibly having to enforce something, the first question that's really critical and often skipped over is, what exactly are you enforcing? Are you enforcing a governing document? If it's a governing document, that means it's written down. That means that it's in a rule or a regulation, it's in your CC&Rs. If it's something called a house rule, well, it's not a rule. Every now and again, I'll have an association ask me to get involved writing a letter, and it's something where there's no written policy. It's just, well, this is what we've always done. This is what we demand of all of our owners. And so, Kelly, please write a demand letter because we're going to have a disciplinary hearing, and we may even want to sue this person. if you can't point to a specific section in your rules or regulations, your architectural guidelines, your CC&Rs, then there's nothing to enforce, because your enforcement is of the governing documents, not just of custom and practice. So make sure that before you go too far down the road of battling with one of your neighbors in the community, make sure that you're battling over something that's written down, not just something that's a preference or a custom in your association. If you can't find the chapter and verse of what the homeowner is violating, then you're not enforcing the governing documents. Now, many times you'll have something in your governing documents that'll be very broad, such as a homeowner will not be a nuisance to other neighbors. Okay, well, there you've got something that's in the governing documents that you can point to. But make sure that there is something written that you can tell the homeowner, this is what we're having a problem with. The second issue that comes along very commonly is it's amazing to me how many associations do not have a written schedule of fines. And the Davis-Sterling Common Interest Development Act very clearly requires that associations have a written schedule of, as the law calls it, monetary penalties. And so I've put up on the screen Civil Code Section 5850. I've highlighted for your reference the language that makes it very clear that not only you're supposed to have your fine schedule written down, but it's supposed to be distributed to the homeowners every single year as part of this new document, starting in 2014, called the Annual Policy Statement. So be careful when you're starting this enforcement process. Make sure that you don't impose a fine which you can't see written down in a written rule called the Schedule of Fines, or fine schedule, penalty assessment policies. There may be many names for it, but don't pull a number out of the air. Again, it's got to be written down. So make sure you have a schedule of fines. Also, of course, I hope it goes without saying that if you're going to impose a fine against somebody, you can't schedule a notice of hearing and then increase the fines before the hearing comes around and then say, oh, well, now we're going to impose the greater fine that was not in effect at the time we first gave you notice to come to a hearing. As you can see, that's Section C. A general note about fines, by the way, those of you who are right now listening to me and are shocked realizing, oh, we don't have a written fine schedule, we need to get something. Please be careful about setting your fines and making sure that they're not punitive. Now, right away, I lost a bunch of the audience, because aren't fines supposed to be punishing people? Isn't that the whole point? Well, yes and no. See, these fines are supposed to deter the violation, but they're not supposed to actually be punishment. So, for example, every now and again, an association will want to impose a particular violation of a $1,000 fine for the first offense. Well, unless it's a really, really, really serious issue, I don't know too many courts that are going to uphold a fine that's severe. You have to really make sure that the fine is a deterrent. It pokes people, but it shouldn't be a knife to the belly. If it does serious damage, you went too far and you're probably punitive. So make sure that the fines are not trivial. You don't want to have a $25 fine. That's going to do nothing. But be careful when the board goes a little too far and wants to set a fine policy of a very large number, such as $500 for the first offense or $1,000. You may be getting in areas here where if it was challenged, a court might find that it's punitive, not just a deterrent. Okay, so we've now decided that we're going to enforce this issue. We have found a rule that we can point to. We do have a schedule of fines. Before we go further and go right to scheduling a disciplinary hearing, let me just suggest to you that there are a number of other measures which may be taken that can be very effective in dealing with the problem, short of setting a hearing, short of sending attorney threat letters, and even going to court. And that is, sometimes sometimes sending a warning letter is enough. Sometimes letting people know that they're not supposed to have bicycles parked on their balcony, if that's a rule in your association. Maybe a warning letter or an email, maybe a personal contact from a director who happens to know this homeowner may go a long way towards a neighborly resolution to the problem. I know, are lawyers allowed to talk about neighborly resolution and not slamming people around in court? Well, I think they should be, or we should be. So that's why I'm mentioning it. Check out the neighborly options first. Now, I know some people get nervous when I'm talking about, well, visiting somebody, knocking on somebody's door, calling somebody. Okay, I understand that certain circumstances may make personal contact, such as a phone call or visit, actually a risky situation. But at least consider it. Is there some neighborly way that we can let somebody know that we have a problem with them before we go too far? All right. If that doesn't work, I'd ask you to remember the Richardson rule of ratchet. The Richardson rule of ratchet, triple R, says you can always ratchet things tighter. You can always increase the temperature of the discussion, but it's really difficult to back off. It's really difficult to go backwards and lower the pressure, lower the temperature. Very often, clients, almost every day, clients come to me and say, we'd like to have a letter on so-and-so. And I very often will discourage the client. I'll say, well, wait a minute. Have you tried, what are the things have you tried before you get all the way to the lawyer letter or the lawyer threat? Because obviously that raises the level of the discussion. It raises the temperature. So be really careful. Make sure that by the time you ratchet and as I put it, go legal, make sure that you really have exhausted the other more informal attempts to resolve things in a neighborly manner. Because once you put it in a lawyer's hands, people get scared, they get angry, they get their own lawyers, and things start having the potential of getting out of hand. So remember the Richardson rule of ratchet, and try the less hostile, the less confrontational approach first if you can. Now, there are some things that are so dangerous, that are so significant, you have to go straight to legal because you really can't wait. I understand that. But there are many times, for example, you can have lawyer involvement and not have the lawyer actually sign the letter. Some clients and managers will send me letters to review, and I'll edit them, but they'll sign the letter. And I tell them, don't CC me, because that tells them counsel is involved. And we don't want people to get all upset. We don't want to go to a higher level of hostility. Here's our last chance to make it a neighborly resolution. And sure, you can always ratchet up. You can always come to me and have that threatening letter later, but try the lesser approach first if you can. All right. Now let's talk about setting the hearing. Of course, Civil Code 5855 says you've got to give the member written notice of the hearing at least 10 days prior to the meeting. Now, be careful here because there is one caveat, and I think I'll be mentioning it again in a moment later. But if you're considering suspending a member's corporate membership rights, such as voting, that's got to be done 15 days ahead of time. So be careful. You might want to talk to your association counsel if you want to preserve that option in addition to other forms of discipline. Note that you're going to need an extra 5 days on that. But the general discipline, the general issue of suspending somebody's rights to use the tennis courts or fining them a certain amount of money, those things, that has to be a minimum 10 days prior to the hearing. And what does that notification have to contain? Well, I'm glad you asked, because the Davis-Sterling Act very clearly says what you have to put in that notice. And I've got to tell you that very often I have people that write to me, write to my newspaper column, and they tell me, they send me examples of violation notices that they've received. And the violation notices sometimes will say, you have violated the association rules and you are to come to the board in 10 days and the board's going to consider discipline. Well, that's not a valid notice. You've got to tell the homeowner not only the date, time, and place of the hearing, but see the next words on the screen there at the bottom. You've got to tell people what the nature is of the alleged violation. So if the problem is that they have barking dogs in the middle of the night, well, then tell them that you violated such and such a rule and your dogs are barking in the middle of the night. Now, you also, as you hopefully know, starting last year, you also have to conduct common area damage reimbursement hearings with the same exact disciplinary hearing process. Well, you got to tell people exactly what you're asking them to reimburse the association and why. And don't forget, you've got to include, look at the last phrase in red, a statement that the member has a right to attend and may address the board at the meeting. The last note there is that the board shall meet in executive session if requested by the member. Please don't ask. It should always be in closed session. There is absolutely nothing to be gained, nothing good to come from having disciplinary hearings in open session. All right? So make sure that you've given enough advance notice. Make sure that your notice contains enough information to fairly give the owner an understanding of what's the problem. I mean, isn't your issue that you want the homeowner to comply? Well, then make sure you give them enough information to know what they have allegedly not complied with, so that they can more appropriately address you at the hearing and be prepared to discuss it. Here's a very important part of the disciplinary statute. Now, we've talked about the timing, we've talked about the notice, but now let's talk about the disciplinary process itself. Civil Code 5855 Part D, the last part, has this very, very important section. A disciplinary action or the imposition of a monetary charge, translate fine, or reimbursement for damage to the common area, shall not be effective. Now that's my underlining. Against a member unless the board fulfills the requirements of the section. So if you don't give people enough advance notice, if you don't tell them enough information in the notice, and you don't let them know what you did in time after the hearing, then your disciplinary action is not effective. Now, in the law, we have two words that are very similar, void and voidable. Voidable is something that may be set aside, but this statute here is describing something that is void. In other words, if the association tries to enforce a disciplinary action where the process was not followed, the 5855 process was not followed, that will not be enforced by a court. So that's void. So make sure, managers and directors, and make sure you understand these very basic requirements of timing and notice content, and as we'll come to in just a moment, that you tell enough information about the issue to be discussed in the hearing so that the homeowner has a fair chance. Okay, now let's talk about the hearing itself. Is this a courtroom? You see the courtroom in the upper left. I have a big problem with a number of commentators and even some pretty well-known lawyers who seem to act like homeowner disciplinary hearings should be treated as if they were a courtroom. It's not a courtroom, folks. It's in the lower right hand of your screen. It's a bunch of neighbors sitting around a table. That's what we're talking about in a disciplinary hearing. So that means that it's not formal. It's not, there's not court reporters or videographers or people taping the session. This is a group of volunteer directors and probably their manager, occasionally their legal counsel, sitting around a table with a homeowner who has a problem with the association or vice versa. That's what this is all about. So let's address some specific issues that are sometimes controversial about conducting the hearing. The first one is dealing with postponement requests. Now, this is where balance and the neighborly part of your governance really needs to come into play, because very often you're going to find people say, well, I'm sorry, but I can't attend that evening. I am out of town, or I have a schedule conflict. Well, that's fine, but you don't have to postpone the hearing. But sometimes perhaps you ought to postpone the hearing. Your requirement under the 5855 statute we just discussed is you've got to send notice of when the hearing is going to happen. The homeowner doesn't have to be present for you to proceed. The homeowner, if the homeowner tells you they cannot or will not attend, that doesn't mean you cannot proceed with your disciplinary hearing. You are required to give them an opportunity to attend, but you're not required to set it on a date that's convenient for them. But now let's talk again about the neighborliness element of this. You're dealing with a neighbor. You're not dealing with some enemy or some shareholder. This is a neighbor as well as a member of your community. You know what? If somebody is not a chronic problem, they're not playing games, you think they're sincere, there's nothing wrong with postponing a disciplinary hearing if the issue is not urgent. I'm just suggesting that you consider postponement requests. Don't automatically reject them out of hand. But on the other hand, you're not required to accept them either. You will from time to time have game players, we've all dealt with them, who just seem to never be able to attend. Well, again, you're not required to grant the postponement, but again, as neighbors who are trying to work things out, keep things hopefully away from the legal beagles, think about granting the postponement if it makes sense to all of you. You don't have to, but sometimes it's a good idea. Who can attend the hearing and who should attend? Well, who can attend is the homeowner. They do not have the right to have legal counsel. They do not have the right to bring witnesses necessarily. They have the right to attend under the statute. That's all the statute says. Now, who should attend? Well, that comes into the category also of not just the defending party, but should the complaining party be there? And I think that very often it's not necessary to have the complaining party come speak to the board. They've already spoken to management. They've already spoken to you. They've let us know what their problem is. I really think that most of the time there's really no reason to ask the complainant to come to the hearing. And by the way, there's some good reasons to not have them come to the hearing, because do we really want two neighbors duking it out in the hallway when they see each other before the hearing or after the hearing? I think most of us would agree that's probably bad for the community. So the homeowner that complained, you know what, they said their piece when they filed their complaint with management or with the board. Really, you want the homeowner who's the defendant, the homeowner who is being complained about, against whom discipline is being considered. They should be there. Now, a lot of times associations, in fact, most of the time, associations don't have any clear guidelines on how these disciplinary hearings are handled. And this is a prime opportunity where you can really help your homeowners by considering policies that let people know what's expected of them and how the hearings are conducted. But if somebody says, well, I'm coming and I'm bringing my attorney, I'm bringing my architect, and I'm bringing my minister, wait a minute. You want to bring a letter from your attorney, a letter from your minister, a letter from your architect? Well, you bring whatever documents you want us to look at, but the hearing is for you, Mr. or Mrs. Homeowner. All right? That's who the hearing's about. So if somebody tries to buffalo you and say, well, you're violating my due process rights, remember the slide I showed you a minute ago. This isn't United States District Court. This is not the Superior Court of the State of California. This is some neighbors sitting around a table trying to help bring a neighbor into compliance and help them be a good neighbor. So due process is the process described in Civil Code 5855. So people talk about the right to cross-examine. That's not something that comes into play in common interest development disciplinary hearings. The cross-examination is, of course, a basic right in criminal court, but this is not criminal court. We're not going to HOA jail. Nobody's going to be incarcerated here. We're suspending somebody's right to use the pool, or we're telling them they have to pay $100 for their purple garage door. Cross-examination is not a right that applies to homeowner associations hearings. Neither does confronting the witnesses. Here's an important question. When should legal counsel be involved in your disciplinary hearings? Now, I'd like to think that most associations don't need legal counsel in all their disciplinary hearings. Most of us lawyers have plenty to do. We don't need to be sitting through these. But you know what? There are times when you have an issue that's serious. You have a homeowner who's threatening legal action. Maybe their lawyer has already written letters about this particular disciplinary issue, or perhaps this is someone who has been a repeat offender, and it's quite probable the association is going to need to be pursuing litigation at some point. There are some circumstances when legal counsel should be involved. I do not believe that in the ordinary situation, your legal counsel has to be at every single disciplinary hearing. I think that's something you want to use your judgment about. Larger associations often need their legal counsel at their board meetings for a variety of reasons, not just disciplinary hearings. Well, certainly if the lawyer's already there, it makes sense to have that extra help and guidance in the closed session hearing. But I don't think there's any legal requirement. And again, the homeowners counsel should not be allowed to attend these hearings. This is not a court of law, and because if they attend the hearing, then you're going to have your lawyer attend the hearing on the HOA's behalf. All right? So no hard and fast rules here, but those are some considerations that may help you in terms of deciding when legal counsel should be involved. Here's an issue too that we have some disputes about, is the confidentiality of the complainant. Now, sometimes it's pretty clear. If you've got homeowners who live in what I call apartment-style condominiums, where people are living over or under each other, and a homeowner on the third floor is complaining about noise from the fourth floor, it's pretty obvious, who's complaining and who's the party being complained about. But I still prefer to follow a policy of keeping the complainant's identity confidential. I don't think that the association should be throwing the complainer under the bus. If they choose to make themselves known, or if it's obvious, so be it. But we really want to try to focus on the violation, not do anything to that might enhance the level of dispute or a disagreement between homeowners. So I like to keep that confidential. And by the way, on the other hand, I also don't think that the board should be reporting to the complainant about what they did with their neighbor that they complained about. I think that should be kept confidential. All right, so we've had the hearing. And by the way, your hearing would be greatly helped by having disciplinary hearing policies. I really strongly suggest you consider setting policies that tell people in advance, here's how many minutes we ordinarily apply to our disciplinary hearings. If you're going to bring documents, please bring 6 copies, 1 for each director, 1 for the manager, things like that. Let your homeowners know what's expected of them. Let them know how much time they have in those hearings. That can really help you as a board have more effective hearings and also be much fairer to the homeowner. I mean, don't you want them to have the opportunity to be prepared if they really have some important things they want to let you know? It'll help you be much more effective interacting, again, with your neighbor. So, all right, so you've had the hearing. You've decided what you're going to do. The first thing that you need to remember is you have only 15 days. 15 days under 5855C, and I've got it on the screen for you, to notify the homeowner in writing of what you did. If you let them know on day 16, we've decided to suspend your right to use the HOA gymnasium, that is a violation, and now you have to start the disciplinary process over. So be very careful. Now, most professional managers know that the very next day after the hearing, what are they doing? They're writing up the notification and sending it to the homeowner. Those of you who don't have professional managers, though, please remember, you can't wait 30 days until the next minutes come out to tell the homeowner what you've done. You've got a maximum of 15 days to mail them a notice of what the board decided to do. Now, if the board decided to take no action or decided not to impose discipline, well, obviously, then there's no deadline because you're not doing anything. But then, don't we get into a matter of courtesy? So maybe you send the homeowner a notification in writing that says, well, following the hearing, the board has decided to not take any action except to warn you and ask that you refrain from this conduct in the future. Sure, you could do that. Another area of controversy are continuing fines. Now, honestly, we lawyers in the HOA real estate community, we don't all agree on this. There are some lawyers that think that homeowner boards are okay in announcing to the homeowner that we have decided to fine you $200 a month until you come into compliance, or $50 a day until you're in compliance. I have a concern about that because the statute says that you have to have a hearing before any discipline is imposed, and the argument on this between lawyers is the continuing fine additional discipline, or is it the discipline itself? I think continuing fines are rarely helpful, because if 1 or 2 fines doesn't compel compliance, then obviously the fine isn't working and you have a legal issue. I prefer, if you're going to have repeated or continued non-compliance, having another hearing, issuing another fine, but after a couple of months, you don't need to keep going. I mean, there's a famous reported case called Ritter versus Churchill from Los Angeles, and if I remember correctly, the Homeowners Association, according to the Court of Appeal, tallied up something like $78,000 of fines, by the way, which were found to be later invalid. That's the kind of problem you get into with continuing fines. Excessive fines I've already described. An excessive fine is a fine that is sufficiently large given the context and the nature of your community that it is punitive as opposed to a deterrent. There's no bright line there, folks, but just be careful to not go overboard in setting your fine schedule so that your fines are excessive. There are some other disciplinary options. One very large association in Orange County found that one of their most effective disciplinary tools, the association supplied cable television to all of its residents. And I know for a fact some of the folks in that community are listening to this webinar right now, and you know who you are. And some of you who are directors have been involved in these votes. Is that they found the association had great success in simply cutting off people's cable television. And that was found to be more effective than fining them $200 because when people couldn't watch their favorite sports event or television drama, all of a sudden they were much more motivated to pay off the fine or to resolve whatever the violation was. So it's okay to be creative. There may be other things in their community that work well for you. Sometimes gated communities will disable people's transponders when they have, you have a transponder or device in each car that is recognized by the guard gate, and so you have the gate automatically open into the community for people's vehicles who are homeowners, but visitors have to stop in and check in at the guard gate. Some associations I've seen have suspended people's rights to use those. They've suspended or disabled people's transponders for a stated period of time. Well, okay, they're still able to get in the community, but they have to check in now at the guard gate like anybody else who's not a member. You're not banning them from their residence, but it is another way to remind them that the privilege and an amenity the association provides for people's convenience is not going to be allowed them for a particular period of time. What you cannot do is you can't cut off people's access to the property. If you're in a security condo building, you can't keep the owner from coming in and getting to their home. That's wrong. You also can't cut off their utilities. Nope, you can't cut off their water, their electricity, their gas. Cable television's not really a utility. That's a convenience or an amenity, but you have to let people come and go to their residence, and you have to make sure the basic utilities are provided. And I know that can be particularly irritating when you have homeowners who, for example, aren't paying their assessments, and the association pays the water bill for people, and you're still having to allow them that water that they're not paying for. But anyways, so you can't cut off people's access to the residence, you can't cut off their access to the community, and you can't cut off their utilities that would otherwise render their home unlivable. How to avoid shooting yourself in the foot. I have a basic philosophy that making bullet-inspired holes in your foot are really a bad idea. So let's talk about some ways that associations aim for the foot and cause themselves problems. First of all, very often argument by homeowners in response to disciplinary issues is that I am being singled out, that I'm being discriminated against, that the board just doesn't like me. Be very careful that you are disciplining everybody who violates, not just the people that are problem children in your association. If you're gonna enforce the bicycle on balcony rule, make sure that you know that everybody who has bicycles on their balcony is required to comply, even if they're on the board, even if they're the president. Everybody needs to comply. Make sure that if you're not enforcing the rule equally across the entire complex, then maybe you shouldn't be enforcing the rule. But watch out for that argument. Now, does that mean you have to tell the homeowner all the people that you have fined or that you have sent violation notices to? Of course not. As I said before, you want to keep the process private, but you need to be able to know that if you ever have the unfortunate circumstance that you wind up in court defending your disciplinary decision, you want to be able to make sure you can demonstrate to the court that you have in fact disciplined and sent violation notices to a number of homeowners, not just this one. Another issue you worry about is waiver, and that's kind of related. They say, well, you haven't enforced this in 10 years, so how can you enforce this now? Well, there are occasions associations will come to me and they say, well, we've actually never enforced this particular rule, and what do we do? And if they haven't enforced it for a long time and there have been lots of violations, sometimes the better approach is, instead of trying to suddenly begin enforcing a rule that is arguably been waived, sometimes it's better to have a board vote to reinstate the rule or reaffirm the rule that otherwise arguably has been waived. Again, if you're not going to enforce a rule, it's better to get it off the books, because having a rule that's not being enforced doesn't help anybody. And of course, there's always the argument of harassment, right? You're harassing me. This is wrong. I'm going to sue you because you're being mean. Well, you know, you're always going to have that from homeowners. I don't have a magic answer to that, except we've got to treat everybody with respect. When somebody claims harassment, you're picking on me. As long as you know that you are enforcing it equally and that even board members have had to comply, then let people say what they will. There's nothing illegal about homeowner discipline as long as you're enforcing written documents and you're enforcing them equally and you're following the Civil Code 5855 process. We've already talked about keeping the privacy of the violator and the complainer. I think that just as we have the hearings in closed session, no good will come of either reporting to the complainer or the community at large about violators, just as it's no good to talk about the complainer to the violator. Keep the process clean and keep it confidential is my strong suggestion. Internal dispute resolution changed this year quite a bit. We had a piece of legislation that I disagreed with very strongly. I think the Community Association Institute also didn't like it, but it added lawyers to the process. It says that a homeowner may bring a lawyer or other representative to their internal dispute resolution hearing. Well, folks, IDR was intended to be a lawyerless process. It was designed to be a process where homeowners could talk to homeowners and work things out in a neighborly way that didn't cost anybody a cent. The change in the law that now allows people to bring a lawyer or other representative adds a new element to the process. And by the way, read it carefully. The statute says a lawyer or other representative. That means a person. That doesn't mean they can bring a team. They can't bring 6 lawyers, 3 architects, and 2 engineers, and their spiritual advisor. Pick whoever's going to be the representative to go with you. It doesn't have to be a lawyer. It could be their architect. If we're talking about architectural violation, it might be a lawyer, might be, you know, a brother or an uncle or something. But if you're going to have a lawyer present at an IDR hearing, the association needs to have its lawyer present. So that means you're going to have to change your IDR policies. You do have an IDR policy, right? Because those are required to be in writing. That's one of the 5 rule sets that are required by California law. You really should modify your IDR policy to now allow for, not only to allow for the possibility lawyers may attend, but to require that people let you know in advance. If you're going to bring a lawyer to your IDR hearing, you have to let us know in advance. Why is that? Because we want to make sure the association's lawyer is available to be present. We're not going to talk to your lawyer unless our lawyer is with us, okay? So consider modifying your IDR policies. If somebody shows up at the last minute with a lawyer and they didn't announce that the lawyer was going to be there in advance, even if you don't have IDR policies in place, I would say you should not go forward with the IDR hearing or the IDR meeting. You should go ahead and postpone it, get your legal counsel there, and give it another try. If IDR doesn't work, there's still alternative dispute resolution. As you probably know, before you sue a homeowner for injunctive relief for violating the documents, you're required to give them a written 30-day pre-litigation notice that says they have the right to request alternative dispute resolution, which typically means a mediator. When we're talking about mediation, we're talking about a conversation. We're not talking about a trial. A lot of people think we're going to go into mediation and we're going to win. Well, nobody's a winner or a loser in mediation. Either the case settles, the dispute settles, or it doesn't. So watch out for that. But the best approach is you hire a retired judge or a veteran attorney, or sometimes there's some great mediators who have never had a law license, but they're really skilled at getting people to meet somewhere in the middle. Another issue is homeowners don't understand that although they have the right to demand ADR with the association, they still have to pay their half. So make sure that the association doesn't pay for 100%. It's supposed to be paid 50-50 if ADR is selected. In the extreme case where it just doesn't work out, and the association has to pursue a lawsuit. Sure, you can sue for the collection of the fines or the common area damage the homeowner caused. You can sue for a court order that we call injunctive relief, saying that the homeowner will not violate this anymore. And you can also, of course, sue for attorney's fees because it's a lawsuit under the governing documents. But make sure that you're right, because Civil Code 5975C says the prevailing party is awarded attorney's fees. Now, it says shall be awarded. That means that if the HOA is wrong and the homeowner wins, you're going to pay their attorney as well as the HOA's attorney. So pick your battles carefully and make sure that you're right. A couple of quick points about discipline and problems caused by tenants. Very, very big topic, but you're not helpless. Because you can hold the landlord responsible. If their tenant is causing a problem, it's the landlord's problem, not just the association's problem. A lot of our association clients work with us to amend their CC&Rs to require that landlords have their tenants agree that if they're going to rent in the association, that they will not only follow the association rules and use restrictions, but they'll submit to the disciplinary jurisdiction of the board as if they were members. A controversial issue with tenants is, well, could an HOA actually evict a tenant who's causing enough of a problem in the association? Well, that's a sticky one. There have been situations I've seen where associations have evicted tenants. I really prefer my association clients not get involved in that. That's a pretty extreme issue, and that's probably a remedy you want to talk with whoever is your HOA attorney if you're going that far. Restraining orders are certainly possible. Sometimes a tenant is causing danger, is harassing people, threatening people, and the association can get restraining orders. Yes, the tenant is not subject to the CC&Rs directly unless they agree as part of their lease to do so, but the association can get restraining orders against people who are tenants, residents who are harassing management, harassing, threatening, putting people in danger of physical violence in the community. So there are a lot of other creative options that you can pursue, but a lot of times it's going to take the cooperation of your landlord. Sometimes the landlord will come into your disciplinary hearing and they'll shrug their shoulders and say, what can I do? And you have to look at them, boards and managers, and say, well, you have to do whatever you have to do to make sure that your tenant is a good resident in our community, because we're going to hold you legally and financially responsible for the problems that they cause. And oftentimes that will wake up a landlord that they're not going to get away with just shrugging their shoulders. Another important landmine as we start wrapping this up here, and a big landmine we're talking about discipline of members, is fair housing laws. And a lot of associations make really significant mistakes in trying to enforce rules which violate fair housing. Probably the most three common violations are rules that are restricting activities of children. You're not allowed to enforce rules that discriminate against kids. Again, I've said many times, if you don't like skateboarding in the courtyard, don't say children are not allowed to skateboard, because you wouldn't allow Tony Hawk, the Hall of Fame skateboarder, to be in your courtyard and skateboard, would you? Well, then just say there's going to be no skateboarding in the courtyard. Similarly, we get into issues with hard flooring. We have homeowners who have in buildings that ban hard floors, and they say, well, I have a medically documented disability of allergies, and I need my hard floor because carpet makes me sick. Well, you're going to need to work reasonably, and that's a big important word here, reasonably with the homeowner to try to accommodate their need for a non-carpeted floor. You've got to protect the neighbor below. So it doesn't mean that you're just going to roll over and let them put in a noisy floor that's going to make the homeowner below miserable, but it does mean that you're going to have to make an exception to your hard flooring rule, most likely, and work with the homeowner to come up with some kind of a buffered floor that they pay for that's going to accommodate their disability while not destroying the neighbors below. And lastly, in the fair housing area, the other area that's very common contention is dealing with pets. People have comfort animals or service animals to deal with their particular disabilities. You may have to make exceptions to your rules to deal with those pets. Does that mean that the pets can do anything they want? They can bite people, they can bark and scare people, they can make messes in the sidewalk, in the hallway, in the elevator? No, absolutely not. But you can't say, sorry, sir, even though your psychologist says you need this dog at all times, you can't take that dog into our board meeting. Well, if you're dealing with a disability and that animal has been prescribed by a healthcare professional, that dog can come into the board meeting. Now, if the dog causes problems, that homeowner can be held accountable and that dog can be ejected for causing problems. But if that dog is a well-behaved, quiet dog, doesn't hurt anybody, then you're probably going to have to make an exception to your rule. Last topic here is there are circumstances where you're not going to pursue discipline. One of the classics is the Hatfields and the McCoys. You know, a lot of our homeowners think that the homeowner association, it's funny, when they want to re-landscape their yard, they want the homeowner association to do as little as possible. But then when the neighbor next door paints their garage door purple or starts practicing the rock band in the garage at 2 in the morning, then they want the association to come in as if the association was a landlord. A little bit of a double standard here. But a lot of our members think that the association is required to handle every single dispute. Boards and managers, there's sometimes that a dispute is strictly neighbor to neighbor, and you may find that the association is not advancing the interests of the community by getting in between those two neighbors and trying to figure out who's innocent and who's guilty. You know what? A lot of times they're both guilty. If you have a neighbor-to-neighbor dispute that's not affecting anybody else in the community and you don't have independent evidence as to what's going on, in other words, other homeowners have not seen the misconduct, then you might refrain from taking action. That's a circumstance where the association is entitled to do that. Remember, homeowners have their own rights under the governing documents. Civil Code 5975A says that the CC&Rs can be enforced by any owner or by the association or by both. So members have their own rights. The association is not the only one that can pursue resolution of disputes when somebody says a homeowner's a problem. Note, however, that homeowners cannot enforce the rules. 5975B says that the association can enforce against a member and the member can enforce against the association. Interestingly, members cannot enforce the rules against a member. So kind of an oddity in the statute. We don't have time to argue whether it makes sense or not, but it just is. Last instance where you may not want to pursue violations is when it's microscopic. Yes, there are sometimes people bring you violations and it's clearly a violation, but it's technical, it's minor, it's not bothering anybody, and it's really not the kind of thing that the rule was designed to prevent. You know what, folks? Sometimes it's okay to be reasonable and not fight every single battle. So you are allowed under the business judgment rule to decide that certain issues you will not pursue. The Behan versus Lido Isle case from the Newport Beach area a number of years ago was exactly that kind of a case, where the association said, I'm sorry, I know that's an architectural violation, neighbor who's complaining, but we don't think that it really helps the community to pursue this issue for a variety of reasons, so we're not going to get involved. That is something that you're under the business judgment rule you are allowed to do. But make sure that you are making a deliberate choice and that there are reasons why you're not going to enforce the violation. Don't let the violation go because you like somebody. That's not legally a valid reason for avoiding discipline. Enforcement without backlash is possible. I think the two biggest suggestions I would close with is, first of all, make sure that you keep at all times in mind that yes, these are rules, these are use restrictions, but you're dealing with neighbors. And try to keep that in the forefront of your mind at all time. You're not just the sheriff. You're one of many neighbors. And secondly, I really would strongly suggest you consider adopting disciplinary hearing policies that you add to your meeting rules that will help let people know what is expected of them and what they will have the opportunity to do in disciplinary hearings. So we've covered a huge amount of ground, and I have to confess, I think I'm about 4 minutes behind my 45-minute promise, but I'm close enough that I hope all of you will give me some grace there. I would be happy to entertain questions. If you have questions for me, if you'll type them in the chat box, I will answer them. I do want to highlight a couple of things. On the screen, you see our next webinar is scheduled for November 13 at 11:30. That will be our second annual legislative and case law update. We'll be talking about laws that will be taking effect or have already taken effect at the in this year or at the beginning of 2016, and important appellate cases. Again, that'll be the same length as this one. And also in October, in the middle of October in Long Beach, the Community Associations Institute is putting on its annual California Law Forum. It's a great opportunity to listen to some of the top managers, lawyers, and other experts in California talk about legal issues that affect associations in California. You can get information on that in a number of places, most of your CAI chapters in California or the caionline.org website will have information. All right. Well, I very much appreciate you listening, and I am looking for questions in the chat box. At the right of your screen, there should be a toolbar and a chat box where you can type in questions, and I'd be happy to entertain any questions you might have now. All right. Well, either we're having a technical problem or people are so shocked by what we talked about today that I don't, oh, I see. We have people using the question box. Well, let me open that and see if I can use that. Normally, it's easier for me to use the chat box, but let me see if I can open that up. All right. Okay, we do have a ton of questions there in the question box. So let me just start at the beginning. Will attendees receive copies of the slides? Dick asks, if anybody would like a copy of the PowerPoint, I'll be happy to send you a PDF of the slides for your reference. Penny asks, what's the difference between a hearing and an IDR? Well, Penny, there are some very important differences. An internal dispute resolution is simply a meeting at which the association and a homeowner tries to come to some resolution of the dispute. A hearing is actually a board meeting where the board decides whether or not to impose discipline against a homeowner. Two very different. At the hearing, you need to have a quorum of the board. At an IDR meeting, you just need to have a board representative. Where can the handouts be downloaded? Jan asks. Well, if you aren't able to get them from the software here on the GoToWebinar software, we can certainly email them to you, or we can send another email with the attachments. They were sent to everyone that registered this morning. Late registrants may not have got them quite in time. Okay, who pays for the attorneys in an ADR? Glenn asks. I'm sorry, Dave asks, who pays for attorneys in an IDR hearing? Well, again, I hope that attorneys won't be present in an IDR hearing, because the whole point of IDR was not to have lawyers involved. But if you have an internal dispute resolution hearing and attorneys are involved, then you know, everybody pays for their own, bottom line. Okay. Keith asks, what about liens? Can a board issue a lien? Well, if your CC&Rs, okay, this is a complicated one, but here's the answer. I assume, Keith, what you're asking is, can we take a disciplinary fine and turn it into a lien against the lot or the condominium unit? And the answer is maybe. Your governing documents, you would have to authorize that for you to do that, and most governing documents frankly don't. And there is a statute in Davis-Sterling that specifically says that if you do have a lien for something like a penalty assessment, you can't foreclose on it. So you can leave it on somebody's property, but you can't take their home away because of a fine. So that's something I would strongly suggest, Keith, you talk to your association counsel about further, because it's a little complicated. Okay, let's see. We have a ton of questions. I apologize right now to the many folks that are not going to get my that I'm not going to be able to get to. Many of you who have questions which are really kind words, thank you very much. Okay. Here's a question from Joseph. Regarding confidentiality of the complaining party, I thought we could only keep the confidentiality of the member if the manager or board can confirm the violation. If we can't confirm it, the owner has a right to know where the complaint came from or where the proof was. You know, personally, Joseph, I don't agree. I just think that if the board is unable to verify the issue, then the board doesn't take action. But I don't think you reveal to the other homeowner, oh, Joe has a problem with you, Sally. So you guys need to work something out. I think the neighbors can approach each other. I'm really always concerned about taking any action that is going to cause even more disputes between neighbors. I don't want to see the Hatfields and McCoys. Sometimes it happens anyway, but I try to keep my boards out of those kind of disputes as much as possible. Okay, let's see. Patsy, great question. What if the homeowner demands I want my disciplinary hearing to be an open session. I want the whole community. The answer is no. It's never a good idea to have disciplinary hearings in open meetings. I'm sorry, homeowner, you demand it be an open session. It's not going to be. It's going to be closed. Nobody's going to be present, not even the complaining homeowner, if there is one. Okay. How does the grandfather clause, Patsy, another great question. How does the grandfather clause affect rules that have been violated and never enforced? Well, let me answer your question a different way. Sometimes associations will pass a new rule that immediately creates violations, and I'm kind of uncomfortable with that. I really don't want to see people immediately become violators when the previous week they were not violators. And so I often find myself recommending that that when you pass a rule, you either give people a certain period of time to become compliant, or in extreme situations, like let's say you have the CC&Rs are amended and you decide to impose a limit of one pet, or say two pets in your building, in your condo building, and you know that a bunch of people have 3 pets. Well, are you going to tell those people they immediately have to pick which dog's going to go off to an animal adoption agency? Nah. What you're going to do is you're going to say, all right, homeowner, we're going to grandfather those 3 pets, but when any of those pets leave you, you can't replace them. You've got to go down to 3 pets. Okay. Ray has a good question. Do executive session agendas need to be published? If so, how much detail? No. First of all, executive session needs to be announced generally. So what you do is you announce that you're holding an executive session and you're going to be discussing. You're going to have member disciplinary hearings. You're going to have some homeowner foreclosure votes. You're going to have a consultation with legal counsel. The general subject. And that's the level of detail. Similarly, when you come out of executive session, you're going to generally say what was done. You're not going to specifically say. Okay. So you don't. Again, you're trying to protect the confidentiality of homeowners. And closed session, typically, the reason why you're discussing things in closed session is you're trying to protect people's privacy or avoid embarrassing them. All right. Let me see if I can squeeze in a couple more questions. Great questions. I'm really grateful to all of you who. All right. Don asks, how do you enforce the restraining order? And I assume we're talking about the situation where we have a tenant and we've had to get a restraining order issued by a judge. That is typically going to be something that if somebody's violating a restraining order, let's say we have somebody who's been harassing and menacing people, typically you call the police. And if the police catch somebody violating the restraining order, then they can arrest them. You also, I suppose, could have further court hearings. It kind of depends, Don, upon the circumstances. All right, let's see. Boy, here's a whole seminar in itself, Frank. How would you best attack the issue of a neighbor smoking and that smoke entering into the next person's unit? They have no shared vents, but the smoke still enters in. Well, in Pasadena, that's no longer a problem because the city council adopted an ordinance completely banning smoking in attached housing. So theoretically, at least, we don't have to deal with that anymore. That's a really difficult issue, and I can't give you a short answer. I think that associations need to be aware of that problem, but frankly, a lot of our condo buildings are not built in an airtight way, so that it's very, very difficult, if not impossible, to keep smoking from going from one residence to another. A couple of you have asked, is it possible to get a recording of the webinar? Yes. This webinar is being recorded right now, and it will be uploaded and posted to the rhopc.com website within about no more than 24 hours. With a little luck, it might actually be posted by the end of today. So you'll be able to go onto the website, or anyone else can watch it at any time in the future if you find it useful to you or your colleagues on the board or in your management company. Well, Joe, let me close with this question, because I'm now at my 1 hour time commitment promise to all of you. Joe asks, is this civil code Kelly is referring to U.S. code or some specific state's code? Yes, this is a California law seminar. I'm a California attorney. All my discussion today is about California law, and I'm referring to the California Civil Code. Those of you in California, the best way to read any California law online for free is to go to the official legislature website. That link is www.leginfo, leginfo.legislature.ca.gov. leginfo.legislature.ca.gov. That is the official webpage of the California Legislature. You click on California law, then click on Civil Code, and you can read any of the statutes that I've mentioned today yourself from the official source. I know a lot of us law firms have the statutes reproduced online, but I like to give out the official reference to the code. Any of you that would like the handouts or a PDF copy of the PowerPoint, please feel free to send me an email, and I'll be happy to send that to you. I'm very grateful for the almost 200 of you that signed up for the webinar today. I hope you found this useful, and I hope we'll talk again on November 13 regarding our legislative and case law update. Thanks again, everybody. I wish you all a great afternoon. Bye-bye.